On the other hand, learned counsel for the private respondents has submitted that once the revision has been filed by the petitioner before the additional collector, he cannot be allowed to question the jurisdiction of the order passed by the additional collector. It is evident from the provision of Section 16 of the Act, 1973, which stipulates about the power of revision, which has been vested upon made to him in this behalf or for the purpose of satisfying himself as per the legality or propriety of any order made under this Act or the rules made thereunder by any authority or officer, call for and examine the order of any case pending before or disposed of by such authority or officer, and pass such order as he thinks fit. Although the admitted fact is that the writ petitioner himself has chosen to prefer revision. But even accepting the opposition on the part of the learned counsel appearing for the private respondents, since the writ petitioner has chosen to approach before the additional collector, therefore, such order cannot be questioned subsequently. But this court is not impressed upon such contention, as because even if any litigant has approached before the authority who is not conferred with such power under the statute, and on that ground the order cannot be said to be legal and proper, rather the authority, even if approached by any litigant, ought to have rejected such application on the ground of being not maintainable due to lack of jurisdiction. But having not done so, the additional collector has not only entertained the revision, but it has been decided by quashing and setting aside the order passed by the appellate authority. There is no dispute about the settled position of law that an order has been passed by the authority having no jurisdiction under the statute. It goes to the root of the issue, and due to lack of jurisdiction such order cannot be sustainable in the eye of law, since herein, under the statute, the collector of the district has been conferred with the power of revision. The punishment order dated 22nd September 1993 passed by the respondent number 1 has been modified by granting him the salary of the suspension period by the appellate authority, and the revisional authority has refused to entertain the representation of the petitioner. However, the fact remains that once the procedure of inquiry is found to be illegal and the punishment order passed on its basis is also found to be illegal, the subsequent orders of appellate or revisional authorities confirming partly modifying such an order of punishment can be considered to be legal. The petitioner has brought on record by means of second supplementary affidavit the boring installation report of Raghunath, which has been signed by the concerned cultivator, junior engineer and the block development officer, and also the petitioner. He has brought on record the receipts of purchase of the boring pipes, pumps, etc., the khatoni of the cultivators, wherein the boring is recorded as the source of irrigation of the plots. He has further brought on record The receipts issued by the cultivators regarding the receipt of the amount spent by them in the process of boring etc. on record, which have not been controverted by the respondents by means of any documentary evidence. Only reply is that the certificate of boring issued by the authorities and annexed by the petitioner in his second supplementary affidavit is a forged document.